will be talking about the solution out of the, Emily just called it data island, basically, that we have developed in our Bitkom working group after Schrems 2 happened. Because as we all know, it's necessary to conduct a transfer impact assessment nowadays, and it's quite extensive. To do that, there are many rules that can be deducted from the ruling itself. And as we're always trying to enable companies to deal with all the requirements in our Bitkom working group data protection, we have been using the past 2 years to do just that and put all our thoughts into a tool that will hopefully improve conducting a TIA in future and enable all companies to really assess their third country data transfers. And I'm very glad that I have Markus Stamm with me here today. He's a senior legal counsel at Nokia and a member of our board of the Bitkom working group data protection. Markus, it's very great to see you at least virtually today. And without further ado, because I know there's a lot to talk about, I'll leave the stage to you.
Thank you very much, Rebecca, and thank you very much for having me here today. As you said, and as we've heard throughout the day today and yesterday, the question of cross-border data transfers into third countries will continue to be a very relevant one, and it is also one where perhaps there is the most insecurity still. There are conflicting requirements we're seeing, there are conflicting statements, conflicting assessments as to what certain case law actually means. And to be perfectly honest, the supervisory authorities also have added a bit to this insecurity. So the question we put ourselves to was, how can we support Bitkom members in fulfilling their obligations when doing cross-border data transfers? And we reached the conclusion fairly quickly that the way to go is a Bitkom transfer impact assessment tool, or BITIAT. And during the next 30 minutes, I would like to briefly give you an overview as to what that tool is going to be doing, what it's capable of, how we constructed it, and what the underlying thought processes are. So we're first going to do a very, very brief recap why we should now be considering transfer impact assessments, especially after the Schrems 2 ruling. And then, of course, we need to address the question of how we can integrate transfer impact assessments into data protection processes. And then finally, which will likely be the most important part of this presentation, you will get to see a glimpse of the inner mechanics of the tool and how it will be actually working, what will the Bitkom members be able to use it for. Now, as we all know, the necessity of the transfer impact assessments is not particularly new. It's become more relevant after the Schrems 2 ruling, but honestly, controllers and processors alike were always required to understand certain risks to the rights and freedoms of the individuals that could be presented by transferring data to a jurisdiction which does not adhere to the common standards set by the GDPR. Obviously, after the Schrems 2 ruling, it's become much more prominent, and Bitkom members have been asking many more questions as to how they can actually fulfill these necessities. As you know, there are certain positions that were asserted fairly early on in the process, directly after the ruling. Would a transfer to countries like the US be permissible at all? In short, we believe yes, but we also believe we need to do an assessment on a per-case basis. Now, obviously, when considering the TIA and the tool-based approach, how far do we want to go and how deep do we want to dig? Obviously, no individual controller and no individual processor can be expected and should be expected to have the same level of detail in their assessments that is necessary for the European Commission to reach an adequacy decision. However, we also believe there are certain common standards and criteria that could be applicable across the board. At the same time, we needed to cover different use cases. No two transfers, or hardly ever are two transfers really identical. And so we wanted to have a solution which enables Bitkom members to assess the risks based on the transfer. Now, obviously, a transfer impact assessment is not a standalone issue. It integrates into the existing data protection and data privacy processes. It's just one of the processes, one of the assessments that needs to be done. And therefore, we've looked at 5 steps that needs to be taken, and these 5 steps are underlying the inner mechanics of the tool and how it works. The first, what needs to be understood is, what are the circumstances of this transmission, of this transfer? There are 7 criteria we've identified. These criteria relate to the circumstances in which a transfer is being made, the scope of the applications. For example, it's a very different question if transfers relate to certain contact information only for establishing, for example, a conference platform such as the one we are using here today, or otherwise are using the data for other purposes. It's a very different story if data were being transferred to other jurisdictions, for example, in the context of providing health services, of providing payroll services. So the first question is really, in what circumstances and in what context are these transfers happening? And for this, the tool will offer a series of yes and no questions. And these yes and no questions are really the only that can be asked and need to be answered. And this first step serves to identify the threats to privacy objectives, which we will now need to look at further down the road as we move through the tool. Once we understand what the circumstances of this transmission, the transfer, the processing in the third country will be, we'll have a closer look at the level of data protection that already exists within the third country. And it's interesting that in many respects, there are a lot of misconceptions about levels of protection in third countries. Levels of protection in third countries can relate to the legal framework, the question of how valid that legal framework actually is, because obviously there's a huge difference between a legal framework that exists on paper and a legal framework that is actually enforced and in use. A legal framework that just exists on paper and that may sound fairly good and rather reliable will not really help mitigate risks to the rights and freedoms of individual natural persons if it is not consistently applied, or if the hurdles to actually use that framework are very substantial or are prohibitive. We have identified 6 criteria, and these criteria include, first of all, the question, are there actually statutory laws that can be relied upon? Are these laws actually enforced? Is enforcement action available? Limitations to that might include precluding certain non-residents, like, for example, the exporter on this side of the pond and the individual data subjects from asserting rights that they would have. Because if that is the case, we then need to look at the question of how these rights can be enforced. We also need to look at what the general legal situation and highest level case law in these countries is. Obviously, the question of case law and to what extent should it be analyzed and to what extent would it be relevant to the individual use case is one where we have to confine ourselves to the highest level. I would say in the US, the Supreme Court level, certainly not lower court level decisions and the ones that are generally known. This would be tantamount to, in Germany, having decisions at the level of the Federal Constitutional Court, the Federal Court in civil and criminal and administrative matters, Federal Court in fiscal matters. That is the level at which we were reviewing case law. Then also the question, are there non-statutory hurdles to assessing these rights? A non-statutory hurdle could, for example, be if even the simplest judicial review were cost prohibitive, or if there were other restrictions, or if there were restrictions on what a data importer could actually tell a data exporter. You remember, especially in case of transfer to the US, this is a highly contested issue. Can there actually be a lawful remedy, one that is effective, if we have to take into account there are limitations on what a data importer can inform a data exporter of? And to cut the long story short, in our in-depth analysis, we believe, yes, that is doable, but it is something that needs to be documented and also needs to be defensible. The data privacy objectives and the threats that are met these data privacy objectives with are also determined in this particular step. And so based on these first 2 steps, we know what kind of environment we're working in, both from the factual side and from the technical side. The next two steps are closely linked together. The level of data protection and the assessment of the legal framework in the target country will help identify the actual threat to the privacy objectives. Now, these privacy objectives could be objectives that are incompatible with national law. For example, keeping data private, keeping data off limits when it is actually subject to search and seizure. And here we have to be careful not to establish a level of requirements that even the member states of the European Union could not meet, because that is certainly not what the European Court of Justice and the GDPR require. Examples for that include rights as to search and seizure. When we're looking at the country profiles, of course, we're considering the question, can public authorities access personal data? And if so, under what circumstances can they access this data? Is there a lawful process to support such an access? Is there a lawful process for asserting rights against it? When that determination is made, we can then understand in more detail the threat to the privacy objectives. And this summary of the considerations we've reached thus far is then amalgamated into a transmission profile. Matching against that transmission profile, we also have certain country profiles, because obviously one of the issues we discussed a little earlier is that the assessment and the actual depth of the assessment cannot be as deep as it is in a general adequacy decision. In this tool, we're not trying to determine the general adequacy of a certain target country for every single conceivable case of a transfer. We're working based on certain transfer situations and based on the risks and the mitigations that present themselves in these scenarios. To support this and to also ensure there is a certain consistency across what measures are applied to individual countries, the tool incorporates a mechanism which is called the country profiles. These country profiles have been collected with the great help of many of the Bitkom members in the Bitkom Data Protection Working Group subgroups that have been working on this tool for the past 2 years. They are based on own analysis. They are based on analysis the Bitkom members have done in similar transfer situations, and they also include legal authorities, so they are indeed defensible. The summary of the country profiles is more broad than would be required in each individual circumstance of transmission and in each individual transfer scenario, but that is on purpose. Only that part of a transfer impact assessment should be documented that is relevant to the individual transfer and to the risks and the mitigations. And this is why in each of the cases, different transfer scenarios can and will lead to different outcomes. It's not clear, and it can't be determined in advance, that a certain transfer scenario applicable for one certain country and one certain use case can be copied, carbon copied as it were, onto other scenarios as well. This is why the tool is scenario based, and each of the processes we're looking at right now will have to be repeated for different transfers. Once we understand the threat to the privacy objectives in connection with the third country profile, and we understand what, if any, mitigations are available, we can then determine the appropriate measures. And these are the supplementary measures that have been discussed fairly frequently publicly, but where there is certainly a lot of inconsistency and a lot of different ideas as to what could be appropriate. The approach to look at individual transfer scenarios is much more realistic, also in this respect, much more realistic than if there were a need to come up with comprehensive appropriate measures that are designed to cover every single transfer scenario, which would be again much closer to an adequacy decision, which the tool cannot and is not designed to enable. These appropriate measures are of course cross-matched against the level of data protection in the third country. For example, an appropriate measure could be theoretically, although this is one you will not find in the tool and for good reason, could be theoretically to exclude access to all data by authorities. Now, obviously, anyone familiar with pretty much any jurisdiction worldwide knows this is a measure that is hypothetically appropriate, but can't be implemented in practice. Personal data, like all other data, is subject to search and seizure, in pretty much every jurisdiction globally that we could be thinking about. The question is, what are appropriate measures that are enforceable and that are effective? For example, an appropriate measure could be, and I believe this is one of the items Cloudflare mentioned a little earlier, to maintain encryption as much as possible, because it is, of course, a difference if an importer in a third country can be compelled to hand over data, but that data is encrypted and can't be decrypted by the means the data importer has, or if they have at their disposal the full unencrypted data, which they have then to surrender based on an administrative order or a court decision. Appropriate measures can also be limiting the amount of personal data. It's interesting that Cloudflare also mentioned this a little earlier. Controllers, exporters really need to consider, do they need to export everything? Is it necessary to have personal data personally identifiable as an export? And this is one where an appropriate measure could be reducing the scope of the data transferred. Obviously, if such a reduction of the scope would mean that the transfer scenario does not make sense anymore because the actual processing that is intended could not actually be implemented anymore, then such an appropriate measure would not be helpful. And by the way, if I made it sound like the tool can enable a transfer and can make it defensible in every single case, that is of course not the case. There are certain cases where the analysis in the tool will result in the finding that the transfer scenario itself would be appropriate, but not for a given third country, because there are threats to privacy objectives which cannot be mitigated and for which no appropriate supplementary measures are effectively available. The list for these appropriate measures, because the bandwidth of what could be considered an appropriate measure and what could work or could not work on a per case basis, is a list of examples, is a list of very relevant examples also, but it is not comprehensive or exhaustive. This is the part where there's a necessary flexibility, which I believe does not lead to an ambiguity, but enables the exporter to actually ensure that they will be able to implement measures that they determine are appropriate and they determine they can also make use of. For example, to have a system by which information is protected, filtered, perhaps encrypted. If this works in the transfer scenario, could be appropriate. If it leads to unusable information for example, a supplier being a data importer in a third country, it is still an effective measure, but it is actually prohibitive because it would make the actual transfer purpose impossible. Once we've completed these four steps, there is a final fifth step where each of the measures is described as it is implemented and what impact it will have on the risks as it is implemented. And this is where the data exporter will also be responsible for checking if the implementation is finally possible. The entire end-to-end view across all the 5 steps that we've been looking at now still makes sense, or there is a breakdown in the process which leads the exporter to determine this export cannot progress. The process from step 1 to step 5 that we looked at here sounds fairly burdensome, but I can assure you, and we'll look into a few examples of what the tool will actually ask a little later on, it is highly standardized. It is not so rigidly standardized that it's just a question like in an installation wizard of clicking next, 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 and producing a full and final report which will satisfy everybody. But it does provide the framework and the tool to the exporter to make determinations on a standardized basis without taking away the flexibility, because even in the transfer scenarios we've been looking at, we cannot comprehensively capture every single scenario. Now, does it perhaps sound a bit too good to be true? I would not say so. No, it's a tool that has a clear accountability output report. You can see an example of what this could look like here. And you can see it starts out with the details of the project. It starts out with the description. It lists the categories. It lists the actual type of an export. It lists the export and its relation to the legal framework in the target country, the mitigating measures. So this is a full and clear documentation, which is also certainly useful in case an export were challenged. Because as you know, one of the very important parts is not only performing these assessments, but also making sure they are documented and their results are defensible. We believe that the logic underlying this, which you can see here, should support this process from start to finish. We have the logic for the transmission scenario, which is then linked to the third country profile database, a database I will be addressing in more detail in just a moment, where we have certain interrelationships between restrictions, possible measures, and possible supplementary measures, and restrictions on these possible supplementary measures. So one thing that the tool is designed to exclude is producing a result of which everybody knows it looks great on paper, but it can't be implemented, and so will be actually punch-holed, put into a binder, put on the shelf, and never looked at again. That is not what this tool is going to do. What are the next steps now? There's two types of next steps. First of all, systematically, we're still in the process of adding country profiles, and that process will actually never be completed, because even country profiles that have been added to the tool will change over time, and new country profiles will become relevant. Also, country profiles may change. If a country has an adequacy decision in its favor, then the country profile obviously will change and the tool will respond differently. These final tests that we were talking about a little earlier, where we check the process end to end, are still ongoing with individual use cases. And if we find we're missing certain typical use cases that are highly relevant, then these would be included also. And supportive measures, next steps, of course, the implementation method of this tool, it will be available to the Bitkom members. It will be available from within the Bitkom member area for the Bitkom members' internal use. It is one of the membership benefits for Bitkom members to have access to this kind of resource as well. And it's not as if individual information contained in the tool might not be available from other sources, also within Bitkom, but for the first time, it's been consolidated into a workable, systematic, and actually usable tool. Now, of course, I've talked about that tool a lot, but what does it look like? And in this short series of previews that we're looking at here, I have to ask for your forgiveness. These are still in German. As you know, the tool is work in progress, and the English translation, there will be an English translation available because the internal use of the Bitkom members does not only include the use in German, and it might be relevant to present these findings to supervisory authorities in other countries other than Germany as well. This translation will be available before the tool is actually formally launched. You can see it will be accessible via the Bitkom webpage. It even has a nice name to it, the Bitiat. And if that, what you're looking at right now, this disclaimer sounds a little harsh, because it says it will not relieve you of your responsibilities as a controller and as a data exporter. That's exactly what it does. It will not be sufficient to say, well, I looked at the tool, liked it, I think that's all fine. You have to be able to stand behind what you input into the tool and the measures you actually get as an output, and you will have to be responsible for implementing them. So that responsibility, I'm afraid, will rest with every single data exporter. So you can see here, this is the landing page. You will first check to what country you will actually be exporting. And this predetermines a couple of the criteria we've been looking at a little earlier. The country profiles are already accessed at this step. The next step then is going to be certain questions, and this is just an excerpt. There are many more questions, but we've selected these three. The example is here a question whether there are any specifically elevated requirements as to confidentiality. For example, if we're talking about special categories of personal data or personal data subject to telecommunication secrecy requirements. Then an issue is, and that happens surprisingly frequently, we discovered this during the assessment of which of the scenarios we should consider by default, if the actual data is collected solely from public sources. And of course, there are use cases where a transfer can actually be made based upon individual consent, which is valid. And so the tool asks that also. And as I said, it asks many more questions before then leading to the final assessment. And this final assessment, as you can see here, as the tool will present it, it will actually refer to the individual viewpoints also underlying court decisions from which these assessments have to be looked at, and from what criteria the tool will derive its assessment for which ultimately the data exporter will be responsible. It's not only the volume of the transfers, the actual protective targets, the actual protective measures, but also, as we said a little earlier, the actual practice of the laws in the target country. The final result will be presented based on certain additional measures that we discussed a little earlier. Now, we're seeing here one example, the current state of the art as regarding technology. For example, here, security monitoring of systems, because obviously security monitoring of systems is one of the examples of a measure which can be validly used in order to detect unlawful data access, which can be used in order to detect data exfiltration. One of the measures, of course, and there are many more. A further example, the use of secure and non-proprietary cryptographic algorithms was also addressed a couple times earlier today and yesterday as a means of ensuring that, at least indirectly, data access is going to be limited, if not completely prevented. And we have free text fields, like the question here, which is very basic, but there are more where the data exporter actually needs to provide verbatim information rather than selecting certain options. Of course, the question of who's involved. Who is the exporter? Who is the importer? What categories of personal data and what categories of data subjects does the transfer relate to? This is one of the determinations we've said a little earlier we'll have to make fairly early in the process. The final report, obviously, this comprehensive report, and here you can see a very short excerpt, not only provides the individual findings and the measures and the results of the measures that have been analyzed as the tool had been used, but also certain background information. Obviously, we can't comprehensively explain every single aspect that is related to the background of individual data transfer to third countries. We can, however, and we do, explain the general concepts behind these requirements, because if the data exporter does not understand them, it will be very difficult for them to understand, are certain measures going to be effective? Is a certain risk actually going to materialize? Is it going to be necessary? Is it even going to be possible to have certain additional measures? Could they be implemented? Or are there situations where the transfer has to be abandoned altogether because it can't be safeguarded as it needs to be? This final transfer impact assessment report is also a report that will be useful for fulfilling the accountability and the transparency requirements. And as much as the analysis that precedes it is very relevant, the final report is also highly relevant because it shows that the data exporter took all of its requirements seriously, understood what these requirements are, understood they are still responsible, and can document how these results that they have reached were actually reached. So in a nutshell, the tool cannot enable every single export. The tool can also not relieve the data exporter of their own obligations, but it can help them fulfill these obligations in a structured and well-addressed way, and it can prevent overlooking items that are certainly relevant, all based on the transfer scenarios and on individual assessments rather than on collective general assessments for an entire country. Thank you very much for your attendance. And with that, my question would be to the moderators, are there any questions? Would the internet like to know anything? Would anybody else like to know anything?
I think we all, first of all, want to thank you, Markus, for explaining the tool itself and also the matrix behind it a bit more in detail. I absolutely invite everybody to give us feedback on what we have done so far. We'll publish a guiding document as well as the tool a bit later in October. And as Markus just said, the tool itself will be available for Bitkom members, but the white paper that comes with it will be open to everybody. We will publish it on our website. So and we always want to include as much feedback as possible on our thoughts. So absolutely feel free to do that. Okay, I see
And
one
perhaps,
question.
Rebecca, while we are at it, could we shamelessly plug in a huge thank you to all the 3 subgroups of the Data Protection Working Group who have been working with many Bitkom members, and great involvement, great engagement of everybody involved in collecting this massive undertaking. Initially, we thought it might be a few weeks until the tool could be up and running. Now, that was 2 years ago.
Yeah, I remember
and
that.
without the help of all the Bitkom members, this would never have been possible. So a huge thank you to everybody in the subgroups who have contributed so materially, and perhaps also a fairly shameless plug. If you're not yet a Bitkom member, it might be a good opportunity to consider membership. This is one of the many benefits you'll be getting. And by the way, this is not a paid advertisement. I do not get any benefits in result of this.
Yeah, thank you so much, Markus. I do see 2 questions in the chat. Before we go into them, I want to also convey my thanks to all the members that have been working with us regarding the development of the tool, but also the white paper. We have been talking about what we're doing, our train of thoughts. We have included the data protection authorities as well, and we have been just discussing that for many working group meetings as well, always trying to involve as many people as possible. And our members in the working group, I don't know how many hours we spent on that exercise and on that project. So thanks, absolutely thanks for doing that and for sticking to the goal of it all. I see 2 questions, Markus. When will you publish this tool in English? Markus mentioned it earlier. We are currently reassessing the language of the German version, and we'll translate it after we're finished with the German text, because we don't want to translate everything twice or 3 times. So I guess it will be October as well, because as soon as the German text is done, I will translate everything and it will be published as well. The next question, when will it go live? I mean, the goal is to publish it at our next working group meeting, which will take place on the 12th and 13th of October in Munich. I think that is still the plan. I hope we will be finished by then, but at least we will be nearly finished, because all the major steps are done. But I think, as you all know, if you're working on such a large project, the last steps, the last details are always the hardest, kinda. But I hope we'll be finished in 2 weeks' time. We'll announce it again, of course, when we have done so. And then you'll be able to access it. I don't see any other questions. Markus, thank you again for explaining it so well. I know that's not an easy task. And I think we'll see each other, of course, in 2 weeks. And thank you for today.